One of the reasons why, the motivating factors for you to go ahead and bring a lawsuit against your careless doctor is because you want to be able to confront him during the course of his pretrial deposition. Can you do that? Can you stare him down and confront him and ask him questions about why he did what he did? How is this possible? How did he destroy your particular life? You want to know the answer? Come join me on a walk through this deserted island here in the Caribbean as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is maybe. The longer answer is most likely no. So let me tell you what I mean. One of the key reasons why you motivated yourself to go ahead and bring a lawsuit, or at least to find an attorney to determine if you had a valid lawsuit, is because you want to ask the doctor why. Why did this happen? How did this happen? How could you have let this happen? And so now you find the best attorney that you can. And your attorney goes ahead and has your case evaluated by a board-certified medical expert. And your attorney comes back and tells you, yes, you do have a valid case. Your lawyer tells you that during the course of your lawsuit, you will be questioned in a pretrial process called a deposition. Lawyers also call this an examination before trial. It's pretrial testimony that locks in your answers. And now, a few weeks or a few months later, your attorney will have an opportunity to question the doctor whom you have sued. And you think in your mind, you have this ongoing thought, I want to be there, I want to sit across from him, I want to be there when you question him. And now, you want to stare him down. You want to ask him, you want to blurt out, you want to tell him that he's wrong when he gives his answers. And you want to be able to confront him. Can you do that? The answer is, you can be present in the room when I question your doctor whom you have sued. That is permissible because you are a party to the lawsuit. In other words, you are the one bringing the lawsuit against this doctor whom you believe was careless. The doctor is there with his attorney. The doctor is required to sit there and answer questions about what he did and why. Now, your goal is to sit there and to listen and to figure out exactly why he did what he did. But you know in your mind that whatever the doctor says that's going to motivate him to give his answers, you believe, before you even get to this deposition, you believe that he's going to say things that are not true. He's going to recall things that clearly are not true. And you want to be able to call him out on it. Can you do that? The answer is no, you can't. You cannot open your mouth. You cannot start arguing with the doctor during his deposition. If you do decide to show up and sit there while I question your doctor, guess what? The only thing you are permitted to do is to sit and observe. That's it. You can't sit there and talk. You can't argue with him. You can't call him out. You can't do any of those things. Because the moment you start doing that, now you are antagonizing the witness. Now you are creating a problem for me, for the defense attorney, and for the doctor. And that is not acceptable. So, since you are a party to the lawsuit, technically you are permitted to sit in on all proceedings that go on in this case. And so you do have the legal ability to come to the doctor's deposition and to sit there and listen and observe. You do not have the ability and do not have the opportunity to open your mouth and to say anything to the doctor. Anything you have to say should be to me, to your attorney. In that instance, you can go ahead and tell me whatever you want, but not in the middle of my questioning. You're going to have to wait until we take a break. Or you're going to have to wait in between questions to whisper something in my ear or to write something down. But imagine this. Imagine after every question or every few questions, you start turning to me and now whispering in my ear something that you think is different or not true about what the doctor has said. Think about what's that going to do to my train of thought. Every few moments you're now writing something down furiously on a legal pad, and now you keep pushing it over to me so that I can see exactly what you're saying or thinking, so that now it interrupts my train of thought so that you can go ahead and express yourself about what the doctor is saying. Is that going to be helpful? Is that going to be beneficial? The answer, in my opinion, absolutely not. Because that destroys my entire train of thought about things that I must ask this doctor. You see, I have a certain agenda here. I need to know, I need to ask certain questions about what the doctor did. And it's not only about what he did, I need to ask questions about his knowledge of the standard of care, his knowledge and understanding about what a doctor in a similar situation would do in this particular instance. I need to be able to ask him what would be a departure from the standard of care. And I need to go through with him his notes about exactly what he did and why. And then, importantly, I need to ask him hypothetical questions. We have different sets of facts. We have the facts as you perceive them to be, the plaintiff's version of the events, and we have the facts as the doctor perceives them to be. And oftentimes they are different. And because they are different, I need to now ask him questions about what his opinion would be if our version of the facts are correct and true and accurate. In that instance, in all likelihood, his opinions would be different if he believes and if our version of the facts are true. If now, every few moments, you're now trying to whisper in my ear about something that you think that the doctor did wrong or said that's not correct and not accurate, now you destroy my train of thought, and that won't be beneficial or helpful to you in your case. Secondly, many times during the course of the doctor's answers, you are going to get frustrated. You're going to get upset. You're going to think to yourself, that's not right. You want to stand up, you want to scream, you want to yell, you want to take the doctor and you just want to shake him and say, what are you talking about? And because of that frustration, because of that anger that I know you're going to have, I would strongly suggest not showing up and not being present during the course of the doctor's deposition. And I will tell you, 99.9 times out of 100, my clients will go ahead and accept that advice because they don't want to be in that position where now they are confronted with the doctor, and even though they are trying to stare the doctor down and get the doctor to look at them and get the doctor to admit what they did was wrong, doing that is counterintuitive. And doing that is not going to be beneficial oftentimes in a medical malpractice case. So why do I share this quick information with you? I share it with you just to open your eyes and help you realize and understand that even though you have the legal right to come into the room and to sit there and to listen to the doctor testify and answer questions about what he did and why, the best recommendation I can give you is don't be there. Why? Let your attorney do what he's supposed to do. Let him focus on the questions he needs to ask. And after the deposition is over, now your attorney can chat with you and tell you exactly what the doctor has said. And at a later time, after the court stenographer, by the way, court reporter is there to record all of the questions that I ask and all of the answers that the doctor gives. And then they compile that into a booklet called the transcript. We are more than happy to provide you with a copy of that transcript for you to read at your convenience. And that strategy works a lot better than the opposite one, which I started at the beginning of this video, which is, can you go and sit in on the doctor's deposition and get frustrated and get angry and you want to go ahead and have an argument with the doctor because you believe he's saying things that are simply not true. I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.